Okay, you're now both officially represented by Saul Goodman and Associates.
We move forward with the suit, lose-lose.
Myth. Can you hand a lawyer a dollar bill and establish an attorney-client relationship and freely confess any crimes without the fear of repercussion? To understand the dollar lawyer trope, we must first dive into the true nature of the client-attorney relationship and privilege. That's right, no explosions or experiments in this, MythBusters. We're using the power of legal research. Who's in charge of this?
You son of a bitch, you're supposed to be on my side.
At its core, this privilege is a fundamental principle of the legal system. It's designed to encourage open and honest communication between a lawyer and their client. It ensures that the client can speak freely with their legal representative without fear that their words will be used against them in court. And this ensures effective legal representation as well.
So have Tanner sue me, but in the meantime...
The basic rule, although it varies by jurisdiction, is that if you approach a lawyer in a professional capacity seeking legal advice, the conversation is privileged regardless of whether any money changes hands. Contrary to popular belief, the establishment of the attorney-client privilege does not hinge on a monetary transaction. This principle is crucial for accessing legal counsel, particularly those who may not have the means to pay up front for legal services. Of course, if you come asking me for free legal advice, I will cut any and all relationship with you because all of my relationships are transactional. I pay my father hundreds of thousands of dollars to tell me he's proud of me. So if money isn't the determining factor, how is an attorney-client relationship actually formed? The most general rule is that establishing such a relationship, a person must consult with the lawyer about becoming a client, and the lawyer must agree to represent them. It is the meeting of the minds between the lawyer and the potential client that forms the basis of the relationship. For example, if someone walks into a lawyer's office, explains their legal problem, and the lawyer agrees to represent them, an attorney-client relationship has been established. This holds true even if no money has been exchanged and no specific fee has been agreed upon. The key elements are the intent to seek legal representation and the lawyer's agreement to provide it.
We'll get you a deal.
Many lawyers require a consultation fee or retainer. While a payment is not necessary to establish the client-attorney privilege, it's often a way to formalize the relationship. It marks the beginning of the professional relationship. These fees can serve as evidence that both parties entered into the relationship with serious intent.
There are so many other professions that don't turn you into Jeff Sessions.
Some legal experts suggest that if one were to use a monetary transaction as a symbol to formalize that attorney-client relationship, a more substantial amount of money would be more convincing than a mere dollar.
A mere representation whose value is determined by the importance people place on it.
So money serves as an evidentiary function in this context of the attorney-client relationship. If it's ever questioned in court whether there is a relationship, the hypothetical $1 being paid would be weaker evidence because everybody knows that lawyers have no kindness in their heart to trade their legal services for $1.
Your only expertise is running up fees, speaking legalese like a dick.
Attorney-client relationships can sometimes form accidentally. If a lawyer acts in a way that leads a person to reasonably believe that they're being represented, an attorney-client relationship might be established even without a formal agreement. This is why many lawyers are cautious about discussing legal matters casually with friends or family if they have any left that will talk to them.
Take that mask off, get some air.
So where does this myth of a $1 lawyer come from? There's another notion in contract law of forming a contractual relationship for nominal consideration. One part of forming a contractual relationship is consideration, which is a term for a valuable thing like money, services, or even a promise. Without a valuable thing changing hands, there is no enforceable contract, nudum pactum. A very pretentious Latin phrase meaning no consideration for the contract, so it's not legally enforceable. Say for example, I essentially want to give you my car for nothing in return, and you want there to be an enforceable contract, and you don't want some annoying lawyer to come back and say there is no contract because there's no consideration, so you don't own this car, I still own it. So, being the smart lawyer you are, you give me $1 in exchange for that car. Now there's an enforceable contract because of the $1 consideration. It's important not to confuse the contractual relationship from the attorney-client relationship.
What do you want? What do you want from me? What do you want from me?
Now we've explored the myth of the dollar lawyer and done a lot of lawyer bashing, which I'm not sorry for because it made me smile. And we can now safely conclude that this myth is busted. We use this. Is the MythBusters gonna sue us? Yeah, I'm a lawyer, but I'm not that kind of lawyer.